students of law who wrote the entrance exams and were not given admission are hopeful of winning their case against the General Legal Counsel. You recall, they sued the school for changing the admission requirements as against the rules initially communicated. Today, at the Human Rights Division of the High Court of Justice, the initial case of interlocutory injunction has been adjourned to November 9. Convener for the group, Daniel Nenesaki, explains the Attorney General requested for the adjournment so it can respond to the interlocutory injunction case. But before we listen to him, some of the students who have been speaking with Joy News say they are disappointed but remain hopeful they will get justice.
Everybody is disappointed. I'm not the only one, because looking at the distance people have covered as far as the north to just come and witness the first day of the sitting, and the case has just been adjourned to the 9th of November. Our expectation was that, being a human rights case, we would get a speedy trial so that we can continue class just like our colleagues who are in school. It's unfortunate. What we can do now is to appeal to the powers that be to give this case all the attention that it deserves, so that we will bring finality to this. We pray for the best, and we hope that justice will be served.
In fact, that is really sad, because we know very well that we have passed an examination, which we know from time immemorial, the pass mark has been 50 and above. That is not a battle. That is not a war. They are our fathers. We are only saying that we believe genuinely that we have passed. So they should let us in. And at the end of the day, Ghana will win.
I don't think it's bad in itself. It's a process. We believe in the legal process. So if the case has been adjourned and we are being asked to come next week, on the 9th, why not? We know we'll get justice for the 499. I'm very calm. I'm very certain that justice will be served. So I'm not really worried about the adjournment. It's a process. It's a legal process. So be it what may, it's fine with me.
My name is Ellen. I'm one of the 499. I think the adjournment, they've spoken to our lawyer, Martin Pegu, and everything is in order. So we'll wait till the 9th and proceed from there. But what can we do? That's the courts. We cannot go against them. We are waiting. We'll still wait. And we are hoping that will be admitted.
Here's convener for the group, Daniel Nenesaki.
Attorney General didn't file any response yet. They were in court. The GLC only filed their response. We've been served with their response this morning. But that notwithstanding, our lawyer is not proposing, wasn't proposing any adjournment. It is the Attorney General that proposed that the case be adjourned. And our lawyer agreed to it. The case has been adjourned to the 9th of November. We will be back here to go into the merits of the injunction application. You see, it is human rights that we are talking about here. We are talking about the rights of 499 students. So delay in itself is a bit worrying, but I don't think, even though irreparable damage is being caused, because our colleagues are reopening school, and we think that justice will be served. That's what matters. Whichever way, we believe in the justice system, in the court system, and we know that we'll have justice.
Joining me in the studio for this conversation is Daniel Nenesaki, who is the convener for the group, and also, let me get his name. All right, so Daniel Nenesaki has joined me in the studio, and then Tony Ma, right, has also joined me in the studio. Good to see you here.
Yeah, good to see you, Taisha.
Well, first of all, before we even talk about what transpired in court today, let's understand what was communicated to you before you started the entrance exams, and what the response of the Ghana School of Law was after you wrote your exams that has necessitated this court matter.
Okay, so every year when you write the entrance exams, the pass mark as established practice has always been 50%. In fact, most of our colleagues who are now lawyers, and some of them who are even in the law school today, all passed through, some of them through the 50. And I always cite myself an example. This is my third time of writing the examination.
Okay.
And
third time?
Three times, yes. And anytime I get 49, 49.1, 49.1, and this is the time I cross the 50% mark. So it is an established practice, and every student knows. In fact, the legendary Maxwell Opoku-Agyeman was on tape saying that if you even get 49.99%, you're not going to get an admission until you get 50.
Okay.
The former CJ, Madam Sophia Kufu, has said the same thing, reiterated that for you to get to the law school, you need to score a cumulative record of 50 in examination. And so that has been a settled practice. So this year, we wrote the examination, and surprisingly, they brought 790 students named that those are the students who have passed the examination. Ordinarily, they would have published the results of all students, but this time, they published just the 790. So upon incessant pressure on the Ghana School of Law to release the results of all students, that's where we got to realize that when they released the results, then we realized that, oh, it's not only 790, but actually 1,289 students really crossed the 50% mark.
Okay, but institutions sometimes do make amends to some of the requirements and stuff like that. That's why I want you to tell me, as you were entering in the exams hall to write the exams, that's exactly what the Ghana School of Law told you.
Exactly.
That if you get 49.99, you are not getting, unless you cross the 50% mark,
yes,
right?
Please. Yes.
All right, so go ahead.
And it was even during the time of Maxwell Opoku-Agyeman that that we wrote our examination. So that is 50% that we know.
Okay.
Then we wrote the exams. Then, like I said, the results came out. Then we realized that 1,289 students actually crossed the mark.
Okay.
But 790 was published, leaving out 499 students.
Okay.
Then we were surprised only for us to see a notice, right? A new notice now telling us that for you to pass the Ghana School of Law, you need to get 50% in Section A and 50% in Section B. And this new rule was not communicated to us at the time of writing the exam.
Okay.
That is the epitome of our argument.
Okay.
That the new rule cannot be in somebody's pocket, with all due respect.
Yeah.
Then will be shown to our face when the results are out. That if the new rule was in existence before the exam, we wouldn't have even complained, but it was not in existence. Then we said, no, that is unfair, because for you to have pulled the new rule after we have passed the examination amounts to, a retrospective law, which is not, allowed in our constitution.
Okay.
And that's where the agitation started, and that's where we are now.
Okay. So today, Parliament has directed the Ghana Legal Council, General Legal Council, to actually admit you and your colleagues who wrote the exams but were not admitted and crossed the 50% threshold. That should come to you as good news.
Yeah, it is a good news. It is so much of a good news, and we thank Parliament. We are most grateful for Parliament. From day one, we petitioned Parliament. As a matter of fact, we petitioned the Speaker of Parliament is one of the people that we petitioned from the beginning of this whole fight, and we've been having so much a very high expectation of them. And today, they've actually passed a resolution unanimously directing the GLC to admit us. We are most grateful. However, we have a case in court. And the fact that Parliament has passed a resolution is a sign that the entire nation is not happy with whatever is going on. That is the unlawful denial of admission to the 499 students who, out of hard work, passed their entrance exams. Because Parliament, 175 members of Parliament represents 175 constituencies in Ghana, and they are the people's representation. So if unanimously they all come together to say that GLC, what you are doing is wrong, and we therefore direct that you do the right thing, I think the whole Ghana has spoken, and we will plead with GLC to listen this time round to what Parliament is saying. Okay,
but today in court, the interlocutory injunction case was adjourned to November 9, right?
Yeah.
What exactly are you demanding from court?
Okay, so we went to court on two issues. First is the substantive case. The main case is that we passed per the criteria that they published in the 14th May daily graphic.
Okay.
And subsequently, when the results were released, they changed the criteria. And we all know that laws don't have retrospective effects.
Yeah.
And therefore, you cannot let somebody go and write exams, and after the results are published, you now bring the rules that you think govern that particular examination.
Yeah.
So that is what we are challenging. We are asking for a certiorari for the court to quash that particular notice, that decision taken by GLC. GLC is a body established by statute, and they are guided, they are governed by the Constitution, Article 23. Article 296, they are not supposed to even take decision. Their discretion must be exercised not in an arbitrary manner. It must not be capricious. So we are asking the court that if what they are doing is unlawful, what they are doing is unreasonable, then the court should take steps to quash it. The second one has to do with the injunction. You know, as we are battling this whole thing, okay, let me add to the first one.
Okay.
You know, this is also against our rights. We felt like we have been discriminated against, which is against Article 17 of the 1992 Constitution. Definitely. We also believe that they are infringing on our right to education. So we went to court on these particular grounds. Now, we're also asking the court to injunct them from continuing the unlawful denial of admission to the students. In effect, what it means is that they should admit us. Let us run with our colleagues. Let us start lectures with our colleagues. When the final or when the substantive case is finally determined and they find out that, okay, per our evidences, or the court finds out that per our evidence and whatever we have provided is we are not able to prove our case in court and we lose the case, they have the right to dismiss us. We will forfeit our fees that we've paid and we will forfeit everything.
Okay.
So that is what we are asking the court. The court should injunct, the court should restrain them from continuing the unlawful denial of admission, which means they should grant us admission.
Okay.
If the court finds our arguments to be very effective and very right, then the court has to restrain them and the court has to impress upon them to admit us with immediate effect.
Okay, so bringing in Parliament also makes it a bit easier for you, because this will mean that you may even get admission even before the court matter ends. But I mean, giving a directive is one thing, and also heeding to that directive is another. In the event that the General Legal Counsel does not heed to Parliament's advice, you are in court already. I'm not preempting, but if the court matter also fails, what other avenues do you have to seek redress? And are you willing to, you know, put them in motion?
I am of the strong conviction that Parliament directive will be taken by the GLC. GLC is a creature of Parliament.
Yeah.
So, I mean, I've heard a lot of arguments when Parliament issued that directive that they cannot, you know, people are saying they cannot order GLC, but GLC is a creature of Parliament. So Parliament, by way, can, you know, direct its own creation.
Okay.
But what I want to say is that we have a lot, you know, people, initially when we started, we heard in other circles that, oh, these are students in no less than they will back down, let them make noise. But we want to assure the Ghanaian populace that once our rights are being trampled upon, we have plans to roll out to the end of the year, to even begin the next year, until the following academic year. Until our issues are resolved, we are not stopping anything. We have beautiful plans, but we can't put them out. We all together with us. I mean, we have planned already. If the court fails out, what do? We have plans instead. We have planned. We have planned that we roll about. We wouldn't put them out now. But we have the strong, like I'm saying, it would be bizarre and unreasonable and, you know, tantamount to, you know, with all due respect, absurdity that everybody is talking to you and you hear. But I respectfully, like I'm saying, the GLC, if you look at the people in the GLC, these are distinguished justices of the Supreme Court and an Attorney General and eminent judges and people with experience and high repute. And we believe that they will not deliberately decide to put 499 Ghanaians' life into jeopardy. I'm very clear on that. And that something might probably have gone wrong.
Okay.
And everybody's drawing their attention to it. We've drawn their attention to it. Parliament has now drawn their attention to it. Everybody's speaking. I'm sure they will hear it.
Let me bring you back to what happened in court today. I mean, what really transpired before it was adjourned, or the matter was not heard at all?
Okay, so what happened is that we were in court. The GLC filed their response today. We were served with their response only this morning in court. Attorney General didn't file anything. So Attorney General came to court and pleaded for an adjournment. Our lawyer agreed to it, and the case has been adjourned to the 9th of November. And let me add something to what my brother said concerning, in 2018, Parliament directed the GLC to bring a regulation to Parliament so that the faculties will run the professional law course. GLC disobeyed. The same Parliament directed Parliament to reduce the fee for marking, for calling for a remarking in the School of Law from 3,000 to 500.
Yeah.
So now nothing has been done about it.
Okay.
We are calling on GLC to do the needful. They are a body made up of human beings. They are prone to mistakes. And we know anybody can make mistake. The whole Ghana is talking and the whole world is talking. At least at a point in time, let us listen to our conscience and do the needful.
Now, you'll be going back to court on November 9.
Yeah.
What are your expectations after you go to appear before court on the 9th November?
We can only hope for the best. I mean, these are you have an issue. You serve almost everybody in the country to speak on your behalf. They kept to be quiet. We sent the case to court. You can only be hopeful and have confidence in the justice system that the court will bring our issues to bear and bring justice to bear. We know that we have a good case. We know we have a good case. And they know they have a bad case.
Okay.
So we are very, very confident that the court will give us justice. Yes, the court will give us justice.
Okay. So, and of course, you've also mentioned the fact that everybody is talking, everybody is asking Ghana General Legal Counsel to do the needful, and they must listen. And that this means that there's a certain importance attached to opening up the law school for everybody to have access to it. Do you know how much of importance that is?
You see, law is one of the areas that affects every area of society. It affects every area. Like any area you find yourself, you need law to probably navigate your way through. Law and medicine, I think in every country, they place this kind of priority to it. If you look at our population right now and our lawyer
ratio, lawyer to citizen ratio,
it is very bad. Actually, it's very, very, very bad. And personally, GLC has not spoken. The law school has not spoken. I don't know the mindset behind the suppression of legal education in Ghana. They should come out to tell us something. But what the president said, that we are just victims of lack of space. To me, with all due respect, it didn't go down well with me. I am not happy with it. We are renting a facility or building a facility that will contain 499 or 2,000 law students. It's not above Ghana. It is not. It is not above Ghana. And we shouldn't make it. It is not an excuse that we should say lack of space, 2,000 law students should be intentionally failed because and the president made us aware that we are just victims, like our predecessors. We are just being vocal. We are not just being vocal. We are tired. Everybody is talking because parents are tired. They spend so much money on educating, on sending their children their work through LLB level. And they get the LLB and you begin to harass them, frustrate them, take them through. Sometimes how you study to go and write entrance exams is very, very, very something. And you go through and somebody sits somewhere and intentionally fails you. You know, previous years, they are not privy to some of these results that we were privy to. So they don't even know that they made the mark or they don't make the mark. Even though they published it, you realize that you have 49, 48, 49, 14, because they put all of them in that bracket. And because they let them unconstitutionally sign an undertaking that you can't challenge your results, they are not also able to challenge their results. But I am telling you, all these people who have written like me, this is my first time, but those who have written like 5 times, 6 times, if we were to remark their first script, you will realize that they have passed. You understand it? So everybody is talking because everybody is tired. They have spent so much in going through the LLB level, and we must not punish them. It is not a sin to be a Ghanaian law student.
Let me add that it is even very sad that Ghanaians will now travel to countries like Sierra Leone or Gambia to go and learn law.
Now Nigeria. Countries
that used to come to our country and borrow judges to be their chief justices we are now going to them to learn law. It's not good. Meanwhile, we can easily resolve this problem. And I'm told that when you go to these countries, it's some structure that is there for them to be educated. And we have structures in this country. And this no space syndrome can easily be resolved. Look, it is Nkrumah, way back, that built the law school for a population that was not even up to 10 million. We are 30 million plus.
30.8 million.
And we are still holding this small law school. Why are we not allowing the faculties who have the capacity to run this law school to run? If they've trained us for 3 years, 4 years through LLB, what holds them back for training us for professional course? And then allowing everybody to write the national bar exams so that when you pass, you become a lawyer. I don't think this is a difficult thing for us as a nation to do. I am of the conviction that I think some people want to hold on and then that entrench, this is the law. But you see, like my brother said, every facet of life now lead law. So imagine if all of us, 30.8 million Ghanaians, are all lawyers. We would have done some of the things rightly. And free us from some of these things we go through. So
this is a conversation that we'll never stop having. We'll keep having this conversation until we see some positive or changes in what's happening at the law school. But I want to wish you well with your case, and on November 9 as you go to court. So Daniel Nemesaki is a convener for the group, and Tony Bam is also a member of the aggrieved law students. I'm grateful for your
and we'll be expecting you in
time.
court.
Definitely, I'll be there with you.